Good morning. This is your Kelso Report for Wednesday, June 13th. I'm your host, Clark Kelso. We begin with a couple of Ninth Circuit decisions involving government law. The first involving the Federal Tort Claims Act. Two parents and their two daughters had filed suit against the government under the Federal Tort Claims Act, alleging that during the execution of a search warrant of their mobile home, Drug Enforcement Agency agents used excessive force against all members of the family, thereby committing the torts of assault and battery and intentional infliction of emotional distress. The district court granted summary judgment to the government on all of the claims. In Avina v. United States, the Ninth Circuit affirmed as to the parents, but reversed as to the two children, concluding that disputed questions of material fact precluded summary judgment as to them. The key question on appeal was whether the agents used excessive force, which, according to California law in cases involving peace officers, is analyzed under the reasonableness standard of the Fourth Amendment. The officers treated both parents and children the same way. On entering the house at 7 a.m. in the morning with weapons drawn and believing they were entering the home of a drug dealer, that was a mistake as it turned out, they found both parents in the living room, ordered both to lie face down. When the husband did not immediately comply, forced him to the floor physically, and placed both in handcuffs while guns were pointed at their heads. They left them lying face down. The Ninth Circuit held this conduct was reasonable in the circumstances. The agents then entered each child's separate bedroom, both times with weapons drawn, and ordered each child to the ground from their beds. Both children were placed in handcuffs. One of them was subjected to having a gun pointed very closely at her head, and both were forced to lie face down for a lengthy period of time in handcuffs while the search was conducted. The Ninth Circuit held that the standard for reasonable force as applied to children requires different behavior by police officers, and that a fact question was presented for the jury whether excessive force was used. Particularly offensive was the fact that one of the officers put a gun up to one of the girl's head when there was no indication at all that the girl, an 11-year-old, was a threat. Our next case involves the Americans with Disabilities Act. In Akwu v. McKim, the Ninth Circuit considered whether a state employee may sue state officers under Section 1983 for alleged violations of Title I of the Americans with Disabilities Act. The case arose after state officials determined that the plaintiff's psychological disorders made her unfit for reinstatement from disability retirement to active service with the California Department of Transportation, Caltrans. The plaintiff alleged that this decision deprived her of her rights to a reasonable accommodation under the ADA and to the equal protection of the laws under the 14th Amendment. Correctly believing that the 8th Amendment would bar her damages claim in federal court against state officials under Title I of the ADA, she brought her claims in federal court under Section 1983. But both the District Court and the Ninth Circuit concluded that Congress's inclusion of a comprehensive remedial scheme in Title I of the ADA precludes Section 1983 claims predicated on the same violations. In other words, all Title I claims must be channeled through the ADA's remedial provisions, and a litigant may not avoid those provisions by trying to bring an action directly under Section 1983, even though the Title I remedies do not include a damages claim. If Congress desires such a remedy under Title I against states, it's going to have to amend the Act. The panel also rejected the plaintiff's equal protection claims and affirmed the District Court's dismissal of the action. Next, we have a criminal law case involving Social Security fraud. The defendant in United States v. Berry was convicted of Social Security fraud and sentenced to 4 months imprisonment and 3 years supervised release. He was a representative payee for disability benefits that were payable to his minor son, and he misdirected those funds for his own benefit. The main issue on appeal was whether the district court committed prejudicial error in instructing the jury on the definition of willfully. In particular, The court instructed the jury that an act is done willfully if the defendant acted or failed to act knowingly and intentionally, and did not act or fail to act through ignorance, mistake, or accident. Well, the Ninth Circuit correctly held that this instruction was incorrect, because it failed to tell the jury that willfully connotes an act undertaken with a bad purpose. And the district court's instruction merged the concepts of knowing and willful without conveying the culpable state of mind that the term willfully is designed to invoke. Notwithstanding this error, 2 of the Ninth Circuit judges believed the error was harmless beyond a reasonable doubt, because it was clear the defendant had received information from the Social Security Administration, putting him on notice that as a representative payee, he could not use the funds for his own benefit. The dissenting judge thought the error was prejudicial and the case factually was a little bit closer. Now we turn to the California Court of Appeal, our first case involving the Indian Child Welfare Act. The parents in In re Gabriel G. appealed from an order terminating their parental rights to their 2-year-old son. The only issue on appeal was whether the juvenile court erroneously failed to notify certain Indian tribes under the Indian Child Welfare Act before entering the termination order. The mother had no Indian ancestry, and at the beginning of the proceedings the father was absent, and there was no evidence to suggest he had any Indian ancestry. At some point during the proceedings, the father appeared and claimed he had some Indian heritage. Now, although there were originally some questions about whether he was the true biological father, and the court kept calling him the alleged father, a birth certificate ultimately was discovered listing him as the father. Well, in these circumstances, where the biological father claims he has Indian ancestry, the notification provisions of the Indian Child Welfare Act are clearly triggered. The juvenile court refused to make the notifications, in part because the court kept saying he's an alleged father, even after the birth certificate was produced. The Second District vacated the order terminating parental rights and remanded so the juvenile court could make the appropriate notifications under the Act. Next, we have a case involving torts and workplace liability. The plaintiff in Brannan v. Lathrop Construction Associates worked for a masonry subcontractor at a school construction site. He slipped on wet scaffolding and injured his back. He sued the general contractor, alleging that his injuries were caused by the general contractor's negligence in sequencing and coordinating construction work at the site, and in failing to call a rain day to protect workers from dangerous conditions caused by slippery surfaces. The Superior Court granted summary judgment for the defendant, and the First District affirmed. The rule is clear in California that under the so-called Privet-Tolan doctrine, an employee of an independent contractor generally may not sue the party that hired the independent contractor. By hiring an independent contractor, the hirer implicitly delegates to the contractor any tort law duties it owes to the contractor's employees to ensure the safety of the workplace that is the subject of the contract. So, instead of suing the party that hired the independent contractor in tort, the employee's remedy is through the workers' compensation system. And that's it for today's Kelso Report. Have a great day in the law.